Case on this morning's docket. That is case number 113130, State of Kansas v. Perry.
Once again, may it please the court, Rick James on brief for the appellant, the state of Kansas. A brief factual background, how we got here today, justices, is this was a drug case. There was a police search of a residence. The police believed the search was consensual. Prior to trial, a motion was filed by the defendant arguing that the search was not consensual. The motion to suppress was granted by the district court. The state, at that motion to suppress, only argued the issue of the voluntariness of the search. As a result, the state filed an interlocutory appeal that wound up at the Court of Appeals. The Court of Appeals, after hearing argument from both sides, denied the appeal. And as a result of that, the state of Kansas filed a motion to dismiss without prejudice the case at the district court level. The case was dismissed, and since the state was still well within speedy trial constraints, the state refiled, in essence, the same case. And this time, when the defendant filed the same motion to suppress, the state argued exigent circumstances and inevitable discovery. Once again, the motion to suppress.
Mr. James, can I ask one quick question, a fact question before you continue? And that
Yes,
is
Justice.
just the dismissal in the district court after the first appeal happened before the mandate came down from the Court of Appeals, right? Just within a few days of the Court of Appeals ruling?
It was within a few days of the Court of Appeals ruling. I'm not sure of whether the mandate was actually down or not.
That tells me what I need to know. Thanks.
In any case, when the second motion to suppress was granted, the state once again filed a second interlocutory appeal and argued once again in front of the Court of Appeals. This time, ostensibly, the state went to the Court of Appeals to argue those two issues that had not been argued in the first case. However, the Court of Appeals did not reach those.
What were the two issues?
The two issues were, instead of the voluntariness of the search, the state argued exigent circumstances and inevitable discovery. The Court of Appeals, rather than reaching those issues.
The issue was whether the search was lawful under the Fourth Amendment. That was the issue.
That is certainly what the Court of Appeals said.
And you would agree that there was no warrant.
There was no warrant.
And so our case law says that that's presumptively or per se unreasonable and therefore unconstitutional unless you can establish one of the 8 or so recognized exceptions.
Yes, that's correct, Justice.
And so you're arguing that if each exception is a separate issue. Is that what you're arguing?
Yes, Your Honor.
And so would
Justice.
if it's yes, the answer, then there would be nothing for you that would preclude you from serially dismissing and refiling on each exception that you might want to raise, except for speedy trial.
Speedy trial, absolutely, Your Honor, would stop the state from doing a serial.
But it's your position that you can dismiss and raise another argument as to why there's an exception as many times as you want, so long as you don't violate speedy trial.
So long as you don't violate speedy trial, because if it were not so, Justice, the state should be able to argue any exception at the Court of Appeals, whether it was argued at the lower court or not. For example, if the issue is the constitutionality of the search, if that is the issue, then that issue was argued at the lower court, at the trial court. Therefore, any of the 8 exceptions should be able to be argued at the Court of Appeals, whether they were argued at the trial court or not, if that is the issue. And of course, that is in essence what the Court of Appeals said here, is that because the only thing argued at the trial court in the original go-round was the voluntariness of a search, the Court of Appeals said essentially what Justice Johnson has said, and that is that the issues of constitutionality, you can't come back on one of the other exceptions under Kansas law to the constitutionality of a search.
I don't understand why the basis for your, what I think is your implicit argument, that you don't have an obligation to raise all exceptions that might apply at the district court level.
Well,
Why don't you have to start there with covering any of the exceptions that might apply?
certainly that would have been the smarter approach, Justice, would have been to argue every exception that the state thought applied at the trial court level. And in fact, since I should admit it, but you know anyway, I'm the one that litigated this case. And as I look back, I think it was a pretty stupid decision not to argue these other two exceptions that I think either one could have had some legs in this case. And whether you call it hubris, which is what the Court of Appeals called it, that I was so confident that it would be, the search would be held to be voluntary, I didn't feel like I needed to. But nonetheless, I don't see how the state is precluded. Because once again, if the issue is the constitutionality of the search, and as this court knows, the way the Court of Appeals kind of deflected this was with the law of the case. And the whole concept of the law of the case is you can't relitigate the same issue. Court of Appeals says constitutionality is the issue, constitutionality of the search. Well, if that's true, then the Court of Appeals should not have said to the state in the first appeal, you can't bring up the concept of inevitable discovery.
How did it say that? I read that in your brief, and it didn't make any sense to me.
Okay.
I mean, quite honestly, because all the Court of Appeals said in its first opinion was, you didn't raise any other issues, so they didn't have to address them.
Right.
Which is kind of standard in our law, that if you don't, if the parties aren't raising an issue, then something not briefed is waived.
Right.
And so you weren't precluded for that reason from bringing up these other exceptions, were you?
No, and I did bring
So,
him up in
then
my
how does that
first.
how does it make sense for you to say that you didn't get to argue those other exceptions? That was, I mean, that's your call, not the Court of Appeals. They're just writing an opinion, and they go, what's in front of us? This is what's in front of us. We don't have to answer anything.
Certainly. And I did bring up those issues at the Court of Appeals, but acknowledged that they had not been argued at the lower court. And so the Court of Appeals said in its opinion that the words they used were the only reviewable issue was the word the Court of Appeals used. The only reviewable issue was the voluntariness of the search.
And counsel, that's a preservation statement.
Pardon me?
That's just a statement about preservation.
Yes,
Okay, you
And-
get the difference.
I do.
Okay.
I do.
And isn't the entire basis of issue preclusion the concept that you have an opportunity to raise all issues, and that any issues that are not raised are then precluded from that point forward if you haven't preserved them?
Certainly, but as noted in my brief and noted in the dissent to the Court of Appeals opinion, it's long been accepted in our state that the state can dismiss and refile even the identical charges and bring in new information, new evidence, as every prosecutor has done probably multiple times in their life, maybe fallen short at a preliminary hearing, has dismissed or had the case dismissed by the court, gone out, collected more evidence, or maybe subpoenaed in some more witnesses, refiled, done the prelim all over again, and continued on, offering new evidence, new witnesses, etc. The idea that the state can dismiss and bring a case back is not a new one, certainly in our jurisprudence. However, what makes this different is this went all the way to the Court of Appeals a second time. That's what made this case different from what's routinely done. But once again, if we apply the law of the case, which is what the Court of Appeals applied to say that the state could not do this, then we have to look at what the law of the case says. First of all, it must be the same case and it must be the same issue. And once again, we go back to the dead horse, which is, what is the issue? Is it the constitutionality of the search? Or is it the fact that the voluntariness of the search was what was argued, and that alone? What is the issue? We use these words in our system. We use words like issue and case. And so that's what this really boils down to here, is what was the issue? Was it the constitutionality of the search alone?
But you will agree that it was the state's burden to prove to the district court that the per se unreasonable search without a warrant was subject to an exception.
Yes, Justice. Yes.
And you did not, in the opinion of the district court and the Court of Appeals panel, the state did not carry its burden.
On either case. On either case. Well, we don't know about what the Court of Appeals would have said on the second case, because they didn't reach the issue. They said the law of the case precluded the state being there. But on the first case, certainly you're right. The district court and the Court of Appeals said the state did not carry its burden on the first case. On the second case, the district court said the state didn't carry its burden as to the other two exceptions. Court of Appeals did not reach that resolution because they said you can't be here, law of case precludes it. I believe the law of the case was misapplied in that it was not the same case and it was not the same issue.
So there is no doctrine that would prevent what Justice Johnson was talking to you about earlier, and that is you're bringing as many as 5 different interlocutory appeals to the Court of Appeals as long as you did not violate the speedy trial.
I do not believe so. I do not believe so. Unless, of course, this court is to hold that law of the case does apply.
Well, I'm saying you've argued that it does not. So I'm
Right.
asking, in your view then, there is no doctrine that prevents the Court of Appeals from hearing 5 different exceptions to the warrant requirement, as long as you're not violating the speedy trial.
I do not believe so. As long as the state hasn't violated the jeopardy rules or speedy trial or any of the other rules that would preclude the state. Obviously, if jeopardy's attached or there's been some sort of final judgment, the state's done. I mean, certainly in those cases, the state can't do anything else. But those things, those doctrines, speedy trial, all of those would preclude the state from having probably a third go. It would be, in this case, the state would have been close just doing it twice. Trying to do it 3 times would have probably been practically impossible because of other doctrines like statutory requirements like speedy trial and jeopardy. Those sorts of things would limit the state's ability to really do this. And once again, I really don't imagine it would happen very often in practice. This was an odd case.
As you've pointed out, in that speedy trial situation, we aggregate the time on the 2 cases. In essence,
Yes.
we treat them as a case.
Right.
Why wouldn't we do the same in this situation?
I believe that when you aggregate time in cases for speedy trial purposes, it's sort of a punishment or on the state. It says that our jurisprudence says to the state that we're not going to let you, if you look at those cases, we're not going to let you simply dodge speedy trial by dismissing a case and refiling and getting a new 180 days. There's a statutory requirement there that when the state does that, the state's trying to get around the statute. There's no statute here to get around. I'm not even sure there's a doctrine to get around unless this court should hold that that law of the case applies. Then there would certainly be a doctrine, but I'm not sure there's a doctrine or a statute to get around here.
In that regard, speaking of doctrines, the dissent in the Court of Appeals mentioned both res judicata and collateral estoppel. Do you agree that neither would apply in this case?
I don't believe in this case they would apply. I can imagine some cases where they might.
I understand, but it was my reading of the dissent that it said, well, they might have been applicable here, but they are affirmative defenses, and so they were waived. My first question is, do you agree that because it wasn't final, we didn't have a final judgment, and the elements of neither doctrine were met here? Wouldn't you agree
Right.
with that?
I agree.
And my next question is, what's the basis for calling those affirmative defenses in a criminal proceeding?
Collateral estoppel and
Res judicata.
res judicata.
I understand they're affirmative defenses under the Civil
Sure.
Code of Procedure, but the Code of Civil Procedure, but what about under the, in a criminal context? Are they?
I'm not so sure they are in a criminal context. The dissent mixes civil and criminal law here in a couple of areas, and certainly I appreciated the dissent, but I'm not so sure that everything the dissent said would be applicable here. And but once again, there's case law out there that has allowed us to go back. I bet most of it's civil and not criminal as well. And as far as I know, this would be a case of first impression. I don't know that this has ever been tried before in this state, where the state has, within speedy trial constraints, filed a second case, gotten the proverbial second bite at the apple. I don't know that it's ever been done before. Perhaps it has, and I'm just not aware of it.
In your second bite at the apple, just in terms of the serial filings of a potential, given this scenario, what happens with Mr. Perry? Is he, then the case is dismissed? Was he in custody?
No, he was not.
Okay, out of custody. So then, does he have to then get another bond on the new case, pay for a bond, and then bond out? As I assume that happens, and so that potentially that could happen 5 times, also at great expense too.
I assume that could, if he had been arrested on the second case. I believe, and maybe Mr. Yao can correct me, I believe he was summoned in on the second case for that very reason. But I'm out of time unless there are further questions.
Your first issue on review was that the Court of Appeals made a mistake in the first instance by initiating discussion about the law of the case doctrine. Is that right?
I believe so. I obviously they held it was a question of law, therefore they had unlimited review, and there's no question that they have unlimited review over common law as well as statutory law. I don't think that's even debatable. I believe that law of the case is an affirmative defense. It was not brought up at the trial court by either party. It was not even brought up in either party's appellate brief. The Court of Appeals, sua sponte, brought up law of the case.
Right, and it asked for supplemental briefing, and am I correct? I just want to make sure I didn't miss it. When I read your supplemental briefing in response to the order from the Court of Appeals, you did not object to the
No.
Court of Appeals considering it. So why haven't you waived that first argument?
Waive the argument that they should not have brought it up sua sponte.
Right, that they erred by doing it sua sponte.
Well, I still believe, whether I objected or not, I still don't believe it was within their jurisdiction to bring it up sua sponte. And perhaps a better response would have been, I should have objected when they brought it up and filed an objection rather than replying to their order to submit a supplement or request to submit supplemental.
Well, you
briefs.
could have done both. I mean, you could
Sure.
have just done the first and then said in the alternative, if you don't agree with
Right.
my objection, then here's my argument on the merits, and off we go. But you didn't do that, and so you think this is an issue of jurisdiction, that the Court of Appeals didn't even have the power to do that?
I think so. I think it was an affirmative defense. Neither side had raised it at any level, had not been raised in the briefs, and I think they brought it up sua sponte. I don't believe they had jurisdiction to do that.
If it's an I mean, at least in civil law, if it's an affirmative defense and the other side brings it up later, if you don't object on that basis, you've waived it. So I get back to why is this even an issue?
And perhaps
for
it
us?
has been waived because there was no objection filed.
Any further questions? Thank you, counsel.
Thank you.
Good morning. May I please the court, Philemon Yao, North Central Public Defender's Office, on behalf of Mr. Perry. I'd like to address the first issue that the appellant raised, which is the Court of Appeal does not have the jurisdiction. I believe the Court of Appeal may raise the law of the case doctrine on its own motion, and the reason being it's in State versus Adam 283 Kent 365. Although the Court of Appeal doesn't do it regularly, but they do have that option if this is a non-ordinary case, which it's not. This is the second, actually, including today, this will be the third time that we are on appeal arguing Mr. Perry's case. Mr. James argued that this is not the same case, not the same issue, and I disagree. The facts of the case are identical at the preliminary hearing on both Perry 1 and Perry 2. The state have different officer testifying at the preliminary hearing, but the factual statement are identical on both appeals. And the state argue that this is not the same issue, and I disagree. The state just basically arguing two different theory on their appeal, but the issue is the same. It's whether or not the search fall within one of the recognized exception to search warrant. And in fact, it does not. The District Court and the Court of Appeal have both ruled that the excuse me, got a brain freeze here. Rule that it doesn't fall within any one of the exception. And the collateral estoppel doctrine also apply here. It's the same party, same issue, and there's been a prior judgment by one panel of the Court of Appeal in favor of Mr. Perry. And I believe the state does not have the option or the ability to relitigate the same issue or the same doctrine over and over again. So I'll respectfully ask the court to uphold the Court of Appeal's opinion.
Counselor, are you saying that collateral estoppel would apply in this case, even though jeopardy never attached?
Yes. I believe it apply also because it's the same party, same issues, and has already been determined once before by a different panel of the Court of Appeal.
Counsel, how can you distinguish your case from the cases that the state discussed, wherein the state may fail for whatever reason in a preliminary hearing, dismiss, refile, and get a second bite at that apple?
The distinction is this: on cases where the state have failed to get a bind over, they go out and reinvestigate, obtain more evidence, come back and have a second preliminary hearing. In this case, there wasn't any new facts.
So your position would be that if the state did exactly what it did, but at the second hearing presented what you describe as new evidence, then you would be fine with that?
I will be fine with that, and I'll probably lose on my second appeal. However,
is there any rationale for that distinction? I'm trying to think of one.
well, the rationale for that distinction is if the state did not complete a thorough investigation to gather all the evidence needed to establish the element of the crime, then I think they have the obligation to go out, reinvestigate the case, obtain more evidence, and move forward with a second preliminary hearing. However, in this particular case, the facts remain the same. There's no additional facts that the state gathered, and there's no additional evidence that change anything in this particular case, and they are the same facts, same party. So that's this.
Well, is there a difference? This was post preliminary hearing. The suppression hearing that you had.
Yes.
Was he arraigned after the preliminary hearing?
Yes, he was.
So
on
so
both.
jeopardy attaches at that point. Does that make any difference in this discussion that prior to arraignment, and there's not sufficient evidence, and they go out and get more evidence and have another dismiss and refile? Does that make a difference if there's an arraignment or not, or is that factor into this discussion?
I don't know the answer for that. I probably need to do more research, but my thinking is the arraignment triggers a speedy trial.
Correct.
So the speedy trial will run from the first dismissal and also will tack on the second.
There's also some formality with the arraignment, and that kind of frames what the state's case is based upon the complaint and the evidence produced at preliminary hearing, and then he or she is then arraigned, and then that kind of again frames the prosecution's case against your client, and anything prior to that time really doesn't, I suppose. And another preliminary hearing would, based upon different evidence, would be just that. And maybe it's a difference. I'm not quite certain that it is, but it might be.
I don't know either, Justice Rosen.
Do we have any further questions? Any further presentation for us?
No, Your Honor.
All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.